my eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Today is kind of a messed up day, but I got a bunch of Judge Mcnally, and I think everybody's gonna like this guy. He could be just as tough as any judge out there. And tomorrow will be Judge. I found enough Judge Bryant. So I sometimes I would change up the schedule. I think next week we're gonna go back to the regular schedule, Monday, Tuesday, Wednesday, Thursday. I just wanted to mix it up a little bit this week because this isn't easy doing this. And I just don't know anymore. But here we go with Judge McNally. So let's make this a little bit bigger. I need to check my settings. Audio. Okay, we're good here.
Is Ruby Van over here by chance? But is Ruby Van over here?
Zoom.
Good morning, ma'am. Your name?
Harley Walkosh.
All right. You pled to disturb the peace under section 771.1. The idea was between 3 and 6 months.
Yeah.
Are you hearing this at all, or? I'm sorry?
No.
Okay. I'm sorry. You have the right to a lawyer. If you can't afford one, I'll appoint you one. Do you understand me?
Yes.
Would you like a lawyer?
He said he would give me the same thing.
I don't know what that means. Who's he?
Oh, I'm sorry, I don't know his name. The prosecutor right here. That's the one that spoke to me. He said that I would get the same thing if I wanted a lawyer. There'd be no difference.
Well, he's not the judge now. I'm the judge. So I'm the one that's going to decide. I'm not saying,
No, I don't. I just feel like that would take longer, and I just want to get this over with and Flat Rock, and be done with Flat Rock. And not good luck ever since I've moved around here.
good. Who was it says co-defendant. Who was the other co-defendant?
I'm not sure what that means. Does that mean the other person that was there?
Another person that was charged.
Tiffany Baldridge. She lives at the 103 apartments. That's the person I was getting
I
into.
assumed they usually stay together. Can you pull her up? And you live at 28617.
I don't live there anymore. I moved out June 11th. I live in Detroit now at my mom's house.
Okay, can you pull up number 11 for me? Can I see that whole thing? I'd like to see yeah, go down. Keep going. Lisa, can you pull that up, please?
Okay.
Optional jail term, 2 days. I don't know what that means. 2 days community service I give?
I'll have to pull it and look real quick.
Okay. Just keep that on. I don't believe I placed her on probation either. But this is under 771.1.
Judge Kirsten's sentencing. He took the plea.
I see.
He did fines and costs or 2 days jail.
I see. Yeah, that wasn't taken under 771. This one is, so I have to place you on probation. I'll make it just for 3 months. How's that? 3 months probation. You cannot leave the state without the consent of the court. You cannot violate you must appear, if you change your address, your place of employment, or home telephone number, you have to notify probation. You have to report as directed. You're not to enter 28616 Walnut Creek. I'm going to order the street fines 50, costs 75. 75 victims' rights fee. I'm sorry, 50 fines, 25 costs, 75 victims' rights fee, $50 justice assessment. So your fines and costs here amount to 200. Probation fees are 60. Your total's 260. You pay that, stay out of trouble. Come back in 3 months, and I'll dismiss your case on motion of the prosecutor. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Do you understand that? All right, Lisa, what is a review hearing date?
December
Oh.
11th at 9 o'clock.
I'm doing 3 months. I changed my mind, so I'm not gonna do 4 months, so it's gonna have to be a little earlier, before December 4th.
Because of the holiday, they're only here November 13th.
Well, then we'll have to make it November 13th at 8:30. And that's it. No contact also with Ruby Vanover, okay?
Who's that?
I don't know. I did not see her name except they listed her as a victim.
Yeah.
Yes.
But
She was there.
at Walnut Creek, maybe?
She was there.
Yeah, I have no idea that is, but I won't be at Walnut Creek. I won't be in Flower Rock no more.
All right, I wish you well. Can you pay all this?
Not today, no.
How much do you have today?
I don't have anything today.
When can you pay it?
You can make payment arrangements?
50 a week?
Yes, that's fine.
Starting tomorrow or next Friday?
Start tomorrow.
I'll just start every Monday, September 8th.
And then this will all be on paper at the clerk's office?
They're gonna go over this with you.
Where do I go now? Probation or down there?
You go down the hall and get your notice, paper notice, then go to probation, okay? Best of luck. Jessica Anaya, Jessica Lynn Anaya, 25R514-249.
Morning, Your Honor. Peter McNally, P784 was for you with MIDC representing Ms. Knight.
Okay. How you doing, Miss Anaya?
You're not ready.
What are we doing on this? Just a plea?
Yes.
Is that what you want to do, ma'am? If you plead guilty, the possible penalties are up to 100 fines, 90 days jail, costs are all those 2 points. Do you understand that? And did you sign the advice of rights and read and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? To the charge of intox, how do you plead?
I plead guilty.
Were you in a motor vehicle in the city of Rockwood, County of Wayne, at or near 22855 Huron River Drive in Rock?
Yes.
Were you the passenger or the driver?
I was just sitting in the driver's seat. I was waiting for my girl to get
And
off.
what did you have in the vehicle?
It was a mixed little, it's called mix. It's just like a tea.
It's got alcohol.
Well, yeah, it's like a twisted tea.
Why are you driving around with
I
alcohol?
wasn't driving. I was just sitting there.
You can't have a. Oh,
Well, yeah,
you weren't driving at the time. Somehow you got the car there, right?
my girlfriend.
So you got in the car and you took when you guys were in the car, you had the alcohol. It's open. You can't do that, right?
Yes.
All right. Nobody's forced you to plead guilty?
No, I was just gonna plead guilty the first time, but I just wanted to see if there was anything else on the record because I do have a baby, so 8-month-old baby, I'm single mother. I won't be drinking anymore as I will.
You had 2 drunk drivings already. I'm surprised you're still fooling around with that stuff. You get another one of those, it's a felony.
Yeah, I understand that.
And then you got a big club.
Yeah, and right after that incident, I had reported to on probation in Monroe County. So I reported there, and it was still in my system, and I'm now on a tether for
None.
till October 31st.
Counsel, anything you want to say?
Your Honor, just based on Ms. Naya's indigency, the fact that she's a working mother, she has an infant at home, we would ask the court to for some consideration on reducing the cost.
Ma'am, anything else? 100 fines, 20 costs, 75 victims' rights fee, $50 justice assessment, 245 or 30 days. Could she pay all that today?
Not fair.
How much do you have today?
I don't have any today.
When can you pay this?
I set up a plan.
Tell me, yeah. 50 a week?
50 a week's fine.
Can you start Monday? Beginning September 15th, we'll make it, okay? That's the fall.
That's great.
If you need more time, what are you gonna do? You're gonna come and talk to me or call the court, say I need to talk to the judge on Zoom, right?
Yes.
Good luck.
Thank you.
Thank you. Afan Nagy El Ghazal.
Caller, sir, please state your full legal name for the record. Martin Philip
Judge.
Thank you very much, Judge. Today is the day time for about 2 allegations. One, August 5th, 25 and warrants 2 guilty with explanations on both counts.
Is that what you want to do, is plead guilty to these?
Yes,
You have 8 technical violations. If you plead guilty, your probation on this could be revoked. And you could be incarcerated for 93 days. Do you understand that? Less any credit for time served. Do you understand that?
Yes, I do, sir.
Did you sign the advice of rights and read and understand the rights?
Yes, I do.
You plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, I
Did
do.
you call Beth?
I did.
For the charge count 1 that you failed to submit to twice monthly testing as ordered on August 5th, how do you plead?
I plead guilty.
Did you fail to submit to testing on August 5th? Sir?
Wait, you said the first one was August. I only failed one. That was the August 5th.
Yeah. Did you fail to submit to testing on that date?
Yes, I did.
Count 2 that you failed to clear all warrants, how do you plead?
Yes, I did. I plead guilty.
You failed to clear all warrants and failed to submit to testing on August 5, true?
True.
Anybody forced you to plead guilty?
But
Plead accepted to both counts. Ms. Wild, your name?
Elizabeth Foster.
Correct me. He was the one going around with the artificial penis on this, right? I'll see, you do something silly like that, I'm gonna remember you as long as I'm here. He's got 8 technical violations. What do you have to say? I mean, come on.
Judge, on August 5th, he was evicted from his residence. It was a rental property. He, according to my client, he represented to me that he let the probation department know. He is now without a residence, a stable residence. The upside to that is that the rent kept going up, so now he doesn't have to pay the rent, which now allows us to go to provision 2 of the complaint. He's already cleared 3 to 4 warrants, so he's been making some valiant steps towards that. I counted 4 to 5 open warrants. He feels that within 2 months, he can have those other remaining warrants cleared. So I'm going to ask the court to allow him to remain on probation. If he were to test today, according to my client, he would test negative.
Of course.
I'm just letting you know.
I know.
If they're using, they're using.
I know. I get it.
And the warrants are his task that he's cleaning up in this compressed period of time. The rent was getting to the point where it was usury. It was just, it was a lot of money. So he can now apply that money to the warrants and continue working on that.
Yes, Your Honor. So I printed, prior to the violation, I printed his record. I have him at about 10 warrants. The one that I am most concerned with, was actually issued April 9th of this year out of 34th District Court. It is for operating while intoxicated. So that is kind of my biggest concern looking.
Was that the offense date or the warrant?
That is the warrant date. The offense predates our sentencing. So he was sentenced January 15 of 25. The offense date over in Romulus, or I'm sorry, in 34th District Court in Romulus, predates that. But he did not appear on that offense. He turned himself in on his warrant, if I'm mistaken corrected. He did the right thing initially when he got placed on probation and then didn't show again after. So he cleared that warrant. And then in the meantime, he didn't show and follow through with clearing that warrant, and they reissued it April 9th of 2025. It's the one that I brought up to him that I feel out of all his warrants, this is probably going to be one of the most important things. It's a major warrant in my opinion. That's my verbiage. The other warrants he has out, a lot of them are civil infractions, very payable tickets that yes, he could find, if he has the finances, be able to clear those up quickly. To his credit, he is compliant with the other aspects of his probation. Outside of treatment, he's completed all his other programs. He's compliant with his treatment. He's attending treatment at Hagera. I get monthly updates from his therapist. The big concern that I have is that since January, he's been ordered to clear these warrants. Again, he did clear this one, but allow us to get.
DNA open today?
Pardon?
Is DNA open today?
I did not look, Your Honor. I'm going to be honest with you. I did not look at my camera.
Call over to 245. Ask, will you, Tabitha? Ask if the DNA is open today. If she knows, she'll know, right?
Yeah, Emily and Jessica will be able to let her.
And where's that case with the OWI again?
It's out of 34th District Court.
Judge, I believe that, so you re-cleared it. He re-cleared that, Judge. He has a court date on the 15th of September. Yes? Yes, okay.
Is that true?
I ran his record August 22 and 25, Your Honor, prior to the violation. I can run it again today to see if that's the case.
Is DNA open today?
It's not open today, but on-site in Lincoln Park is.
We're gonna give you the sentence date, Lisa. And you said that's the 15th?
Yes, sir. We'll record it, so.
How long do you want to go, Judge?
Just a couple weeks.
September 18th at 8:45.
September 18th. I'm sorry, what time, Lisa?
8:45.
At 8:45. You're gonna go test it on site today. You make sure you show up there on the 15th. And I'm talking about on 34th. You come back here on September 18th at 8:45%. Do you understand that?
Sorry.
We're gonna see how you're doing today. I hope you're negative. Good luck. You make sure you follow up. If you missed it, if I find out you missed that case, we're gonna have a big problem. Do you understand? Good luck. Thanks. Faraz, Cartez, Sharp, 24G700688. The charge is here, this is 24G700688. State your name again.
Faraz Sharp.
Have you talked to a lawyer yet today?
No, sir.
You're charged with failure to complete the domestic violence program with 12-week follow-up. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No, that's fine.
All right, if you plead guilty, if you're found guilty, that could be, you'd be subject to a 5-day jail term. Do you understand that?
Yes, sir.
Did you, you're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a hearing. You'll be giving up your right to remain silent, your right to testify if you so choose, your right to a hearing. You're waiving the requirement that they prove you guilty by a preponderance of the evidence. Do you understand that?
Yes, sir.
And you still wish to waive your right to a lawyer?
I'll take a lawyer. That's fine. I'll take one.
I'll enter a not guilty plea. Okay, I'll give you a lawyer. I really want you to come here. Is there a reason you can't come here in person?
It's 3 hours away, and
Oh, you don't live in Southfield anymore?
no, sir. I just gave my probation officer the address.
All right, Lisa, let's reschedule this. We're going to set this and get you a lawyer. We're going to give him a lawyer, and we're going to set it for my next probation docket day, I guess.
September 15th at 9 o'clock.
September 15th at 9. I'll let you up here by Zoom, okay?
Okay, thank you so much.
All right, thank you. And we'll set you up with a lawyer real early that day, okay?
All right.
They're running around here like crazy today. Thank you. Good luck. People against rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
As to count one, did you fail to attend your scheduled visit on August 18th at 25? How do you plead?
Yes.
How do you plead?
Yes.
Count two, that you failed to pay your fines and costs as ordered. How do you plead?
Yes.
Count three, that you failed to submit the testing as ordered on July 15th. How do you plead?
Yes.
Count four, that you failed to submit the testing on August 12th of 25. How do you plead?
Yes.
You failed to submit the testing on both July 15th and August 12th. I can't hear you.
Yes.
Did you fail to pay your fines and costs as ordered and also failed to report to probation on August 18 to 25?
Yes.
Anybody force you to plead guilty?
No.
All right, I'm going to accept plead all four counts. Your name?
Yes.
So tell me what's going on with him. I placed him on probation a year ago, and all of a sudden he pops up with these four violations. What can you?
So he's compliant, otherwise he's completed all 3 days on the court program. He completed the alcohol level 2 class with the victim impact panel. He's been compliant with testing in the past. I haven't had an issue with him. He has dropped out of monthly testing. His balance, I did check this morning. It does look like he's made a payment since I issued this violation. I believe his balance is like 145. At least I'll be able to double check.
Counselor, why didn't he show up?
On
The test dates.
The test dates. Okay, so on July 15th, he did a late test that day. He missed the test. He informed probation, and was instructed to test late, and he did test late. Also, Judge, during this time, he's got a monitoring device that is evaluating, I believe, alcohol with another jurisdiction.
What's that for? SoberLink?
DV. Is it a sober link? It checks every 30 minutes. Yeah, it's for.
No, it's a screen tether.
Okay, so on the 15th, although he did test late, and we were assuming he was negative, he was compliant with that device, which could add further credence that he was not using. August 12th, he came into the test facility.
You got a drunk driving in August of 24. I see what happened. That was.
This was a DV case that he has this on board, right? Okay, on August 12th, he came into the facility to test, didn't have enough money, and was instructed to come back on Friday, which was payday, and he did.
Judge, I just looked at the onsite records today. I just have that he missed on July 15th and he missed on August 12th. There's no testing in between them. The last time he missed a test that I spoke to him was in June, and I did have him appear for a makeup test in June, and he did do that and was negative. But I have nothing since the July 15th date. It's just 2 no-shows back to back.
Why aren't you showing up for testing, sir?
I'll let you explain.
Why aren't you showing up for testing?
My color is now blue, so.
Well, it's not going to be anymore.
And I have blue for you guys.
So I have him on orange at onsite. I can only see our testing. I didn't know that he was testing for another court. If he's testing for another court, I have to look him up under a different court to be able to see it. I'm only seeing him for us.
When was the last time you have a valid test? June from him?
It would have been June 24th.
Yeah, that's not good enough.
But again, I can double check now, because if he is testing for Southfield, they're only putting his testing results under the Southfield's PO, not under me.
You missed too many things. Here's what I'm doing. You're to serve 1 day in the court work program, pay $35 for that. You're to pay additional costs of $75. You're to pay additional probation fees of $60. I'm extending your probation until December 18th of 25. You have to test weekly for the next 2 months. Then I'll make it bi-weekly. You pay your money, you do your court work, and we'll have you out of here, but you got to start testing.
When was that date, Judge?
December 18th, probation's extended to. And you're going to pay an extra $170 in court work with costs and probation fees.
Your Honor, realizing that he's also testing in other jurisdictions,
As long as she can run the test results, I'm not looking to burden somebody. I'm just want to make.
As long as he's testing, but I can see other results. I just have to look.
You can deal with that, okay?
I think it's important to know now that we've communicated that he is testing with another jurisdiction, so that test can, for that, he can satisfy.
Sit down and talk to her. When can you pay this?
How much is the total now?
$175.
Well,
Because I think he owes 140.
145.
On these 175, I'm just going to give you until October 2 to pay. Will you write that down on my register?
Yes.
Pay by October 2. Listen.
Judge, there's some confusion. I think he has a remaining balance of 140.
Hang on a second. These costs right here have to be paid by October 2nd. Okay? Whatever else, I'll let you set up the new payment plan. How's that? Okay? So you're going to sit down and talk to her. Thank you. Wahidin Mohammed Al-Fari, 25F243956. Good morning, Mr. Hamid. How you doing?
Good morning, Your Honor. How are you? You looking good, buddy?
Yeah, I don't know about that. Getting old. How's it going? Good?
I'm very blessed.
Good. Okay, so we're gonna your appearance, and then we'll get you out of here. You're gonna
for the replete Sabi Hamid P34663 appear on behalf of Mr. Farah. I had opportunity to discuss this matter with the city attorney. We're authorized to on this matter for a 1 to 5. And Mr. Roger.
So what happened? Did he initially paid it? Is that what happened, Lisa, on this? Is that what?
Yeah.
I'm looking right now.
I
Yeah,
just
he
wanna make
paid
sure-
it and then
All right, let's talk about that. Judge Pope's docket in this session had the usual mix of payment plans.
Sound familiar? Everyone's hyping AI coding. You try Cursor, but it just doesn't live up to the hype in your
So let's call in the prosecutor 249 and we'll go from there. There was a no contact provision in effect. I don't care if you called her up, said, "Come see me." I don't care what the situation was. You have no business having any contact with any victim here. None. You're violating court orders. I don't have anything on the restitution issue, so I'm going to have to ask Mr. Urick about that too. But here's the deal. I'm going to tell the prosecutor I'm not going to take this under HIDA. Counsel, your appearance again. I'm sorry.
Again, Your Honor, please call Bloomberg on behalf of the city. What given, Your Honor?
She had another case taken under HIDA for domestic violence. She pled guilty a month before this event. She was ordered not to have any contact. She went over there and picked this card in violation of the no contact order. I'm just not going to take this under HIDA. I will allow you to withdraw your plea if you'd like. I need somebody to check on restitution on this one. It sounded like when I read the report, there would have been quite a bit of damage. And I recognize again that they made arrangements, the victim and the defendant, to speak, but that does not excuse your obligation to courts. You can't do these things. So that's how I feel about it. You guys figure it out. If you want, I will reschedule it and let everybody grab their bearings, and I'll reschedule it for or you can go talk and resolve it today, whatever you'd like.
Your Honor, I would like to withdraw a plea and would like to discuss with the counsel. I'm sure we get it resolved.
All right, I'll just make a note. Told defendant will not take per HIDA. Defense allowed to and did withdraw a plea. So we're back to square one. Now, this case has been going on quite a while. So if it's not resolved today, you're probably going to have to set it for a final plea trial and a trial. Plea allowed withdrawn. Okay, ma'am? Thank you. Destiny Danye Henry, 25W83784.
Afternoon, Your Honor. Michael Croft, representing the Senate, is approaching.
I have not done this in years, but I cannot take this plea. I'm not going to do it. Your name? I want to make sure I got this straight.
Yes, Your Honor.
Domestic violence charge, HIDA, in front of Judge Heston.
Correct.
Sentenced, no contact provision. Goes and ends up having a reasonable, has some kind of a discussion with the victim, kicks the car door, damages the car. Sounded like a significant amount of damage. I tell you guys I won't take HIDA. Then you come back with 771.1, and now you're going to have me take a plea to a municipal civil infraction. I mean, I'm not blaming you. I'm just telling you, I'm not taking it. I will not take this unless there's a valid reason for it. What's the valid reason? Is she running for Congress? I mean, I'm dead serious about this. What
the whole nature of
she already pled to destruction property. And then we go back to 771. And I can't even. I'm not even sure I'm able to. Yeah. What is going on?
Well, the prosecutor and his officer was in great pains and stakes to try to find the best appropriate one that they
Get
could.
the prosecutor and the lieutenant in here, please. My Lord. And the lieutenant. I just feel like sometimes, and I don't want to be the bearer of bad news on this one because I see it all the time. Where's the accountability of anything anymore? She violates a judge's no contact there. Guys, I got to see you both in here, Lieutenant, and you guys, can I have your names, please?
Good afternoon, Your Honor. Please call William Merrick on behalf of the city of Woodhaven.
Lieutenant Toller, David.
Guys, what do you think? Does anybody have any clue what I'm thinking? I want to tell you how I'm feeling. I take this young lady's plea. I read the report. I'm aware of the fact that she pleads to HIDA under 7694A. I'm sorry. Yeah, takes a HIDA plea, I should say, on the domestic. Goes in front of judges. Is ordered not to have contact. Has contact with the victim. Sounds like it was a mutual thing. He wasn't innocent in all this, but as you know, I don't order victims not to have contact. I have no authority to do that. They get into a dispute. She kicks his car. I take a plea under HIDA, unbeknownst to me at the time, that she just pled on a domestic in front of Judge Hessen for HIDA. I send it back saying I'm not taking HIDA. You send it back saying take it under 771. And now you guys are sending me a municipal civil infraction?
If I can speak to that.
I want to hear it. I got to tell you, I try not to get involved in what you guys do. I bite my tongue up here all the time, on both sides.
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device.
This is ridiculous. So yes, I'd love to hear it.
Your Honor, to begin with, I believe the court was concerned about accountability. The people believe that given the fact that she is on an active probation, which is so there may or may not be some form of a violation of probation, not required to be triggered by a conviction, but simply the contact issue. The second feature that developed.
There is no conviction now if I take this plea.
Correct.
There's a conviction for nothing.
And there wouldn't need be at a violation of probation hearing. The contact is a violation of probation in and of itself. As in real time this matter was developing, we tried to reach the victim again. So he has been hailed by the probation department and by us and has been non-responsive. These young people have an ongoing custody issue before the front of the court in the Third Circuit. This young lady, as I understand it, is well employed at a call center, I believe, and obviously the court has all the discretion to disagree with the people, but I believe that given the complexion of things as they develop, specifically with respect to the, what's the word I want? Inactivity or incuriosity of the victim in trying to shepherd this case, I believe that this was a reasonable outcome. Thank you, Judge.
And Your Honor, we obviously respect your concern for the violation of the first order, but as counsel stated, my thought process was similar. If Judge Hessen has an issue with it, she can be held accountable for that violation before that court not be penalized here in a separate subsequent case.
Guys. I must be missing. So because I say I can't take this under HIDA, and I'm not going to because it was a domestic dispute, and she just pled guilty to and been sentenced on a domestic dispute a month earlier. And then you guys said in the 771, and now you want to tell me Judge Hessen can revoke. Judge Hessen can take steps on her case. Number one, I don't care what people do. I made that abundantly clear. I don't think we treat people better. Call center, great. Lawyers, doctors, dentists, priests. I don't think we treat anybody differently based on who they are, what they do, who they know, or how much money they make. And I've said that for 30 years, and I believe it. So let's throw out the employment thing. Let's not talk about employment. Let's talk about something called justice. Let's talk about something called justice. Let's talk about something that has to do with holding people accountable. Giving them breaks when they're deserved. And everybody deserves second chances. But not in this scenario. I find this to be, first of all, let's just call it the way it is. Judges are not really legally authorized to tell people that they're not going to do something that the prosecutors are off. This used to drive me crazy when I was a young judge. Still bothers me a lot. Because there's no justice being served here. I just want you to know that's my feeling. And when I'm done doing this, I'm going to take this plea. I'm going to take your plea, man. You're going to walk out of here with something that is 99.8% better than what they offered you 2-3 weeks ago when you pled to malicious destruction of property. And the only one that called it was me. Because it isn't right. It's not right. I don't care what anybody. You could line up 150 prosecutors, they could all agree with him. 8,000 defense lawyers, line them up, they could all agree with me. I'm still going to be the one to say this is wrong. It's just wrong. It's just wrong. The idea that Judge Hessen can or cannot do something or should or shouldn't do something is part of this agreement I find to be hogwash. But the thing about me is I'm not going to overstep my bounds. At least I do my level best every day I come in here to not overstep my bounds. I think this is ridiculous. I'm just telling you.
I'm going to let you in on a little secret. My husband found this new 87 cents generic Viagra.
You have a deep problem going on right now. And that deep problem consists of, for whatever reason, a lack of respect for the judicial system. And it's cases like this that make me say, gosh, I can understand somebody thinking this is nonsense. I just can't. Now you're going to walk out of here in great shape, and the only thing is you had to listen to an old guy talk to you and call your case 4 times today. I just want to go on record and say I don't agree with this. I don't think it's right. And if somebody gets hurt in this, the blood's going to be on somebody else's hands. That being said, you're recommending a fine of $150 under 94-2. I think I have absolutely pretty much no authority, although I just don't believe in the logical nature of your argument, Mr. Urick, but nonetheless, I'm going to take that plea, municipal civil infraction 94-2. What is it called again?
It's misuse of streets and sidewalks, Judge.
Misuse of streets and sidewalks. Now forgive me, I gotta laugh. Did she spit on the sidewalk? I don't want to talk about it. I mean, I feel like I gotta go take a shower after just even presiding over this case and take a plea to the charge of misuse of streets and sidewalks. How do you plead? Responsible? So she kicked the hell out of the guy's car. He's not here. He didn't show up for restitution. Original charge is dismissed. Motion to the prosecutor. Agreement of the defense. Ma'am, go down the hall and pay your $150. And consider yourself, you should probably go buy a lottery ticket or 49 of them right now. Have a nice day.
Thanks for watching. Make sure
Build a website you love with Wix. For your words,
What's your name, sir?
I am an interpreter, Your Honor.
Oh, yeah.
Gonzalez.
Okay.
He's talking to the attorney. He says he doesn't need me. He doesn't know why they told me that he only left the one for the first appearance. I don't know if you want me to stay.
I want you to stay. I want you to bring that defendant in with his lawyer. Tell him the judge would like to talk to him.
Yeah, they are talking in the.
I'd like him to come in here and talk to me. Okay? Can you tell him to come in here? Or do you want me to tell my courthouse officer, do this for me? Stay right there. Go tell the lawyer and the defendant. What's his last name?
Slolanti Gonzalez.
Slolanti Gonzalez. Bring them in here. And his lawyer. And the file. Lisa?
Yes,
Not a happy camper, right?
I know.
Just so you know,
I know.
he's in there talking to Prophet about.
The victim's here also, just so you know.
I want all the interpreter fees added up on that case. Do you understand me, Lisa?
Yes,
Good.
I'll check.
Thank you. Put them in the file, please. And I will have a little conversation with this gentleman. Can you come up here, Mr. Interpreter? Mr. Crawford, come on up with that file. David Istolart Gonzalez, 25W86565.
Morning, Your Honor, Michael, representative defendant stands to my right.
Name,
David Islar Gonzalez.
your name.
Mauricio Fernandez de Cordova.
And you are a certified interpreter in Spanish, correct?
I am, Your Honor.
Okay. And your name, Mr. Lucas.
My name is Carl Lucas.
What did you tell me when you came in the courtroom and I asked who you were?
Was an interpreter for this case, Your Honor, of the Mr. Gonzalez told me that he doesn't really need me. But yeah, the request was for the first appearance.
Did you tell him that? Yes?
Yes.
You told me you needed an interpreter.
Yes, I am. No.
The whole courthouse has been telling me that you were capable of carrying on conversation with them. I don't know why you're smiling. No. When it's your turn to talk, I'll tell you. The entire courthouse has been telling me for weeks that you're able to converse in English. You told me you needed an interpreter. If you want to play a game, I'll somehow figure out a way to give you permission to put a badminton court out back here, and you play out there. Go ahead. You don't bring interpreters in here because you want to be a wise guy. You don't come into a courthouse and act like you need an interpreter when you don't need an interpreter. You got it? You got it? How disrespectful. How incredibly misleading and disrespectful, Mr. Lard. You know the good news about this? This upsets me. I'm not going to treat you worse, but you will pay for every nickel that the court's incurred and interpreted. Do you understand that? You want to play another game? Figure out how much his fee is going to be today. I'm gonna release the interpreter, Lisa, please. I want that included as well. You guys take your time. Go back and see, go over the report. Maybe there's some kind of an explanation that he's been taking English classes since the time he was arraigned back in July, and suddenly, he's capable of speaking English. Maybe there's some kind of an explanation for all of this. I sure hope so. You've been a smug guy with me from the beginning, Mr. Gonzalez. Be smug. You can be smug.
If you live in an Alabama zip code and have 0 DUIs in the last 5 years, listen carefully. I was an insurance agent for 30 years, and what I'm about to tell you could save you up to 80% on your auto insurance. Here's what the industry doesn't want you to know. Alabama drivers pay the most for car insurance out of any state in the country. As we all know from the recent 2025 leak, insurance companies are now in trouble for overcharging Alabama drivers by as much as 80% for the same coverage. We call drivers in this state gold tier clients. The one.
This is not the place to be smug. This is serious business. This is very serious business. Go out. You still look like you're smiling to me, and I just can't even imagine. I cannot even imagine somebody looking smugly at the judge with a smile on their face after the judge just discovered, after bringing in interpreter after interpreter, that suddenly you wise up and you admit that you can speak English. I watched him say, "Follow me," and you didn't even hesitate. My court officer here, half an hour ago, 20 minutes ago, were you in the courtroom? He said that, and it was abundantly clear, but it's been kind of clear before. But see, I find it so outrageous and outlandish that somebody would look a judge in the eye and tell them they need an interpreter if they don't need an interpreter. I'm going to give you the benefit of the doubt. I hope you enjoyed yourself. I hope you got a lot of money too, because these interpreter fees, they're not charging $22.12 an hour. Go talk to him, Mr. Crawford. Sir, you're released. Thank you very much. My sincere apology that somebody forced us to contact you and bring you in here when you had nothing to be here for. Go take your time. Here, give him this, please. I need to get off of this bench right now. Keep smiling, Mr. Istler. Keep smiling. I hope you're enjoying yourself.
Mr. Lucas, I'm just going to put you back in the waiting room until they recall that case, okay?
Thank you.
Your client pled to attempt MDOP back on August the 6th. The prosecutor dismissed the malicious destruction of property charge. I ordered a pre-sentence report. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletion? Mr. Lucas, your name?
My name is Carl Lucas.
All right, so I'm going to listen to what they have to say. They're urging me to adopt the recommendation. I'm going to go on to Mr. Istelart Gonzalez, and then I'm going to ask you if you have anything to say, okay?
Yes,
Sir,
sir.
would you like to say anything?
You're speaking to me?
No, I'm asking Mr. Istelart Gonzalez.
Thank you, sir.
Is there anything you would like to say, Mr. Lucas?
I did submit a letter to the court demonstrating the damages that were done to my vehicle, and I paid to have those corrected. I just want reimbursement.
How much were the interpreter fees, Lisa? And I want you to estimate how much we're going to pay that gentleman today. I think it was $160 an hour. I don't know.
They charge $160 an hour with a 2-hour minimum and an $80 travel fee.
So that's $400 on my math.
Yeah, he's been here 3 times, so I figured it to be $1,200.
15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Change your address, your place of employment, your home telephone number, you must notify probation. You have to report as direct. You're to attend the anger management program with follow-up. You're to obtain and maintain employment, provide proof. I see that you are working, making $2,000 a week. You're not to have any contact with the victim, Carl Lucas. You cannot write, phone, see, text, email, or communicate with him in any way or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 4 days on the court work program. There's a $35 a day charge for that for a total of $140. You're to pay fines $100, costs $100, $75 victims' rights fee, $50 justice assessment. So fines and costs are $325. You have probation fees of $300, bring the total to $625. You have attorney fees in this case of $100, bringing the total. Let me just do my math here again. $325, $625, $725. You have court work program fees of $140 for a total of $865. I want to make sure that I'm getting the fees right, Lisa. You're to pay restitution through the court to the victim, Mr. Lucas. You're to pay through the court in the amount of $1,265.50. That brings your total to $2,130.50. You're to pay interpreter fees of $1,200. Oh. Your total here amounts to $3,000.
Augment Code is the best AI coding tool for professional software engineers. They've put a lot of time and effort making.
Crime does not pay.
$300. $30.50. If you violate, your probation could be revoked. You could be incarcerated for 45 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate, you're going to get 45 days, or you can get 45 days. Do you understand? Yes. You have all of this to pay.
And would we even pay one?
I'm not going to be very patient with you. Okay? How much do you have today?
$100.
I'm sorry?
$100.
You make $2,000 and you're single every week and you don't have more than $100?
That's the relatives outside.
I hope you've enjoyed this little experience. I cannot believe you did this. I know you're sitting there smirking again.
It's not going to be.
Pardon me?
It's not going to be.
Go ahead and appeal. And I hope the record's abundantly clear. Because you've had fun in the system. You have no respect for the system. Go ahead and appeal. Like I'm afraid. Give me a break. Go ahead and laugh all you want. You're going to pay $100 a week.
Get him, Judge.
And if you need more time, you're going to have to come in here and talk to him. Okay? Let's all have a good laugh. Let's all have a good laugh with Mr. Installart Gonzalez. Beginning September 15th. $100 a week. Thinks he's funny, huh? You better show up for everything, Mr. Gonzalez. You don't. You go to jail. That'll be funny, huh? Have a great day.
Get him, Judge. Get him.
His first $100 payment is due today, correct?
Yes.
Hello, Joanne.
Yeah, we'll accept the check.
Get him, Judge.
Or credit card, whatever you want. You get points. See what? What did he say, Mr. Crawford?
What's that, Mr. Esquire?
Come on back here.
Come on back here.
You're not going to see me in court.
Oh, no.
No, you get to go in front of another judge and play with them for a while. How's that?
Oh, get him, Judge.
Enjoy your journey through the criminal justice system.
Get him, Judge. Get him.
Mr. Lucas?
Yes, sir.
I'm sorry that you had to listen to all of that. And just amazed that somebody, I don't know what's going on anymore, to be honest with you. But that was, I'm not surprised that his conduct elevated to the point that it did on the date of the offense. Let me just put it. Have a great day, sir.
Yeah,
Good
thank
luck
you for your time.
Why did I?
Duh. That guy was pissing off that judge big time. He thinks it's funny to commit these crimes. Then said, "Oh, I only have $100." He makes $2,000 a week. Come on, these judges weren't born yesterday. I'm telling you, crime does not pay. Believe me.
People against Andrew Scott Scartarazzi from 25B710359. Appearances, please.
Good afternoon, Your Honor. Nora Ali on behalf of the people.
Neil Rockine for Andrew Scudderassi.
Sir, your name?
Andrew Scudderassi.
Detective?
Good afternoon, Your Honor. Detective Crystal Tulas, Brownstown Police
All
Department.
right, so we have a sequestration order in effect. I assume none of these are witnesses back here except the officer who will testify first, correct, Ms. Ali?
Yes, Your Honor.
And is there anything else we need to bring up before we go on?
Nothing further, Your Honor.
Reckon?
Not for me.
Who did you say, Lisa, is on Zoom or?
They just disconnected. They didn't have their name on
Okay.
there. They just said it was for this case.
Do either of you know who that could be?
I do not know.
Mr. Reckon?
No.
Okay, all right. Call your next witness.
Yes, Your Honor. The people call Officer Jacob Lee.
Okay. All right, officer, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, you may proceed. Is it L-E-I-B?
L-I-E-B.
L-I-E-B. My apologies.
Good afternoon. Could you please state your name for the record?
Officer Jacob Lee.
Mr. Lee, where do you work?
I work in Brownstown Township as a police officer on patrol.
How long have you been employed there?
I've been employed at Brownstown for just under 2 years. I've been a police officer for 9 years.
What are your roles and responsibilities in this capacity?
As of right now, I'm a patrol officer on night shift in the Brownstown Township.
Were you working in this capacity on April 10th, 2024?
I was, yes.
And what were you doing that day?
Everything that would entail a normal night shift on patrol, answering calls for service, more specifically.
Could you just move up closer to that microphone and keep your voice up a little bit, please? Thanks.
Yeah, absolutely.
Could you repeat the answer just because it was a little low?
I was answering calls for service most of the night, including the call that we received.
Okay, and you indicated a call was received. Do you recall who that call was received from?
From our dispatch, dispatched me to the Brownstown Police Department station's lobby.
Were you in the lobby at that time?
I was not, I responded there.
And when you responded, did you make contact with anybody?
I did, I'm in contact with our victim in this case. Chantel Sadarsky, if I'm pronouncing that correctly.
And what happened when she was there?
So we were dispatched there in regards to a domestic violence complaint. I made contact with Chantel. She informed me that she had gotten into an altercation with her husband.
Any response?
I can withdraw the question. We can
I'll
strike what you
sustain,
said
you can
about.
rephrase. How's that?
Yes. Well, I had asked what happened when she was there.
And he started to say what she told him.
Yeah, so what he said before that should be.
Well, that will remain on the record, but anything, he didn't really answer it. He just started and she said, and then he objected and I said, I'll sustain it. So you can rephrase your question if you'd like.
Okay, I can rephrase the question. That's okay. When she arrived, what was her demeanor like?
She appeared upset.
Okay. And did you make a report based off of, or did you make a report that night?
I did, yes.
And was your body cam on and functioning that night?
It was.
Did anything else happen that night?
I interviewed the female, Chantel. I also interviewed the other party involved, Andrew. They both completed witness statements, and I typed a report based off both of their stories.
I don't mean to interject, but one thing I want to say, Mr. Rockeye, you brought the thumb drive with you.
I had it, yes, Your Honor.
So you're just going to retain that. We're just going to know that that's the thumb drive. The exhibits go back to you, but
Yes,
I remember I told you to bring it today and.
Yes, and I have it.
Okay, so that's the way we'll play that. I'm sorry, go ahead.
I'm just trying to recall. Okay, and did anything else happen after those interviews?
No, I typed my report and submitted it to the Detective Bureau for further investigation.
Okay. Just one moment. Nothing further, Your Honor.
Cross.
Thank you. First of all, thank you for opening the door for me as I walked into the courthouse. I appreciate that. I appreciated that courtesy.
You're welcome.
Officer Lee, let me, it's pronounced Lee, correct?
Correct.
And you're in plain clothes, but you have a badge on. So are you a detective now or?
Nope, this is my uniform for court today.
Yes, sir. I'm going to touch on a few different areas and try to get through them as quickly as I can. I ask a question that's confusing, you just tell me, all right?
Okay.
Now, your answers, have to be verbal. So they have to be out loud as opposed to a nod or a shake of the head. You understand that?
Yes.
You wrote a report in this case, yes?
Yes.
I presume at some point you've looked at it before you actually submitted it, yes? And I presume that at some point you looked at it before testifying today?
Yes.
You reviewed it today in the prosecutor's conference room?
I did, yes.
Now, there are certain things about report writing that's want to kind of go through those relatively quickly. There's a purpose in preparing reports, yes?
Yes.
The purpose is to memorialize things that occurred?
Yes.
You try to write it as when things are still fresh in your mind?
Yes.
You try to document things that are relevant and important, yes? And you're trained when you write a report to include the relevant and important facts?
Yes.
And you're trained to write an accurate and complete report, is that true?
Yes.
And when you're satisfied, and when I started, officers actually wrote reports, but now you guys type them out, yes?
Yes.
And so when you start typing your report and you finish typing it, you're able to review it. And when you're satisfied that you've discharged your duty to prepare an accurate, complete, and reliable report, you then print it and submit it as your official report in the case. Am I correct?
Yes.
And you did that in this case?
I did, yes.
So when I'm leaving that value and those things you're calling values ndio sasa zenye tuna train on tunazi.
You also submitted body camera in this case. Am I correct?
Yes.
Now you had body camera for when Ms. Scardarossi was your original encounter with her in the lobby of the police station.
That's correct. Yes.
You have a subsequent body camera with her when you exit to hand her a blank written statement or a statement to fill out.
I would imagine is that on the same body camera?
Well, do you recall if it's the same body camera or not?
If you said subsequent, so I just wanted to clarify. It should be my same body camera, yes.
Yeah, but is it a different actual recording or don't you know?
I don't recall.
You actually then made a third recording where you recorded a telephone interaction with Ms. Scardarossi, yes?
Yes.
Objection. He was testifying.
He's asking a question. He's asking a question, a leading question. It's okay. It's cross, overruled.
Yes?
Yes.
And then you were wearing body camera when you actually went out and spoke with Mr. Scardarossi.
Yes, that's correct.
You reviewed your body camera before testifying today?
I did, yes.
How many different body camera did you review before testifying today?
Just myself.
Just your own?
My own.
The ones that I just referred to?
Yes.
Lobby interaction with Ms. Scardarossi? Yes?
Yes.
Body camera, where you handed her a witness statement to fill out?
If that was included in my body camera, I watched my body camera from the entirety of the interview in the lobby with Ms. Chantel Sedergoski.
I'm just trying to.
In other words, what you're telling us, you didn't see on that body cam, you handing her a statement to fill out?
That's what I'm asking. That was my next question, Judge.
Is that what you're telling us?
I believe. Can you rephrase the question? I'm trying to clarify. I watched my body camera in its entirety from my interaction with Chantel.
I understand. The end of your body camera, what was the last thing that you observed on your body camera with Ms. Scardarossi?
I don't recall.
You just watched it?
I didn't just watch it. I watched it when I was preparing for this case. It was not just a second ago. Okay. I don't recall what my last interaction was.
How long ago did you prepare for testifying today by watching your body camera?
I reviewed my body camera footage on Sunday night while I was working.
All right. So I'm going to ask the same question the judge asked. When you reviewed your body camera, did you see you handing Ms. Scardarossi a witness statement to fill out?
I do not recall. I did have her fill one out.
Did you see on your body camera you handing Ms. Scardarossi a victim notification card?
Objection, Your Honor. Asked and answered.
Yeah, I think it is.
It's a different question.
Wow.
There's a purpose to this last question, if you let me ask it. And saying goodbye to her, like watching her leave the station.
If that was the last interaction, I don't recall if she was walking away or what my last interaction was. I would have handed her a victim rights card with the report number.
I'm just asking if you saw that on your video.
I don't recall.
Preparing. And how about, did you see when you were watching your videos in preparation for testifying today, your interview or your phone call with Ms. Scardarossi that was on speakerphone?
I did see that, yes.
And you saw that in preparation for today?
Yes.
In your police report, you never wrote that Ms. Scardarossi pointed, or that Mr. Scardarossi pointed the barrel of the gun at Mrs. Scardarossi's neck. Am I correct?
That's correct. I did not write that.
You never wrote that Mrs. Scardarossi demonstrated with her finger to her neck the barrel of the gun pointed at her. Am I correct?
Can you rephrase the question?
Yes. You never wrote in your report that Mrs. Scardarossi demonstrated the barrel of the gun pointed at her neck. Am I correct?
That's correct.
In fact, Mrs. Scardarossi told you that the gun was never pointed at her. Am I correct?
You are correct.
Look at the judge.
And in your report, you wrote, Chantel noted that Andrew kept the handgun in the holster during this incident and never pointed the firearm directly at her. Isn't that what you wrote in your report?
That is correct.
Why can't I make any changes without an admin approval? Why?
With Monday.com.
One of the things that you do as a police officer is, of course, when you interview witnesses, you're trying to get information, right?
Correct.
And you're also trying to assess credibility, right?
Correct.
And you pay attention to whether a witness's story changes. Am I correct?
Correct.
And where the witness changes stories or changes the narrative, that could be evidence that the witness is not being truthful.
It could be, correct.
You weren't told, as your report reflects and as you testified a moment ago, that Mr. Scardarossi ever had the barrel of the gun pointed to Mrs. Scardarossi's neck. Am I correct?
You are correct.
You would agree that the neck and the head are two different parts of the body.
That's correct.
Pointed to the neck is different than next to the head, correct?
Correct.
Had the gun been pointed, or had Mrs. Scadarrasi at any point said the gun was in any way pointed at her? Head, neck, chest, anywhere, you would have noted that in your report, am I right?
That's correct.
That's an important detail.
That is, yes.
And she never told you that?
She did not, no.
Now, Mrs. Scadarrasi, well, strike that. You're aware that Mr. Scadarrasi owns a company. Are you aware of that?
They may have mentioned it on scene. I don't know what the company would be, the name of the company or any of their roles in the company.
Well, one way to assess a witness's credibility, particularly in a case like this, is to attempt to corroborate what a witness tells you, right?
Correct.
So in the interview, Mrs. Scadarrasi says that she owns a company. Correct?
I don't recall if she says she owns it or she works there or they own it together. I don't recall.
Did you do any research to attempt to evaluate that?
No.
Did you do any checks on Lara or on a state corporate website to see if that's true?
I did not know.
So you don't know if she was lying to you or misrepresenting who owned the company when she interviewed you?
Objection, Your Honor. All of this is irrelevant at this point, whether he did the Lara search and whether or not she had spoken about the business.
That he doesn't remember whether she said she owned it, he owned it, or they both owned it.
And I'm asking whether he did anything to determine whether or not she misrepresented that.
But then you said something about lying. Repeat your last question.
Certainly. You said, you didn't do anything to determine whether Mrs. Scadarrasi was lying or misrepresenting her role in that company, did you? That's my question.
Okay, but he doesn't remember what she said. So I'm going to ask you to move on.
Okay.
That's not a proper question.
Okay, Ron. Now, in your report, you repeatedly referred to Mr. Scadarrasi's phone as his phone. Yes?
I believe so, yes.
Okay. And Mr. Scadarrasi referred to, when she interviewed with you or when you spoke with her, referred to Mr. Scadarrasi's phone as his phone, H-I-S, his phone, correct?
Correct.
She never said that his phone was, quote, marital property, did she?
No.
She never referred to it as marital property, did she?
No.
She never indicated to you that, well, it's ours, so I have I can look at it because it's part of the marriage.
Objection, Your Honor. Asked and answered.
I think I've made the point. She referred, yes, Your Honor, multiple times. Now, it's important when you're interviewing a witness to actually to be actively listening. Yes?
That's correct.
So when the witness says something, to actually like pause and think, why did the witness use that word or why did they say that? Yes?
It would be helpful.
Helpful.
Yes.
Mrs. Scadarrasi, I characterized her conduct to you as vindictive. She used that word vindictive. Do you recall that?
I do not recall that.
Did you inquire of her? Let me ask you a question. There was a discussion about her sneaking into the home. You were interviewing her and she said she had snuck into the home at night, 1-something in the morning. You remember that?
I recall that conversation, yes.
Does it help refresh your memory about her referring to her behavior as vindictive?
I don't recall using that terminology.
Not you.
Hearing that terminology. I don't recall.
Okay. Let's talk about what consent means. You're familiar with the word consent or permission, yes?
Yes.
As a police officer, you know consent means that someone is giving you permission or that another person has the ability or has said it's okay to do something, yes?
Yes.
Okay. In regards to the phone, I mean, there's obviously a couple of different ways as a police officer to establish consent. I'm going to go through those with you, okay? One is if a person says, yeah, I had consent, like they actually gave me written consent, for example. Yes?
Yes.
Another is if there's actually circumstances that show that the person did or did not have consent, right?
Yes.
$6.99 every plate dinner ready in 30 minutes? Let's go. Every plate is my favorite.
Mrs. Scadarrasi told you that she did not have consent to access Mr. Scadarrasi's phone, correct?
I don't know if she used the word consent, but
Finish your thought.
she told me that she went over there and retrieved his cell phone.
Objection, hearsay.
All right.
Your Honor.
This is actually a prior inconsistent statement because I asked Mrs. Scatarassi these questions. And
So you're just saying you're gonna use it for impeachment?
correct, Your Honor. Yes.
Overruled. But you are asking a lot of hearsay questions.
Well, these
They're
are
not
all,
they're not all inconsistent statements, so I'll.
well, the record will bear that out, but I'll make my argument to the court at the appropriate time. She specifically said on the issue of consent, there's no way he'd ever give me any kind of code while he is awake. Remember her saying that?
I believe so, yes.
That's evidence of a lack of consent.
Objection, that calls for a legal conclusion.
Any response to that?
What's that?
She said that calls for a legal conclusion.
I don't know that it does, but I'm asking for the officer's assessment. So.
He's not a lawyer. I'm gonna ask you to move on.
Okay.
Stay in the objection. If you answered that, I'm striking it.
She never said to you, I had permission or I had consent to access his phone at while he was sleeping at 1 something in the morning, did she?
No, she did not.
And she indicated to you that they were separated, with marital separation?
No.
Okay. Tell me about his computer. What did she say about his laptop?
Your Honor,
I don't recall.
Objection, irrelevant.
Well, it goes to it's impeachment again. Goes to prior inconsistent statement.
You've got to be more specific.
I'll be more specific. She never even mentioned.
Well, I'm asking you to be more specific with what statement that's.
Oh, sure.
mentioned.
Sure.
What she never denied that she.
You know what? I'll withdraw and I'll rephrase it to make it easier. In your interview with you, Mrs. Scatarassi never said to you, so by omission, she omitted sharing with you that she'd attempted to access Mr. Scatarassi's laptop in his home that night. Am I correct?
I don't recall. She attempted to retrieve a passcode from his cell phone.
His cell phone.
Yeah.
She never told you. You have no recollection of her telling you that she attempted to access his laptop. Am I correct?
I don't recall that.
Would you agree that if she had indicated that you made reference to the phone in your report, correct? Yes. There's no reference to the laptop in your report. Isn't that true?
That's true.
And had she told you that she tried to access his laptop, that would be something that you would have put in your report.
Depending on if it was if she removed it from the home or if it had anything to do with these allegations, it would have been noted.
Okay. All right, I want to focus for a second on one more issue with Mrs. Scatarassi, if I could. So, between 1:40 and about 1:50 was your first conversation with Ms. Scatarassi in the lobby of the police department. Giving you a time frame, about 10 minutes. Yes?
Is that a question?
Yes.
Yes, it sounds pretty accurate.
During that interaction with Mrs. Scatarassi, she never said to you that she disabled any of the security cameras in the home. Am I correct?
You are correct. She did not tell me that.
Your second conversation with Ms. Scatarassi was between 2 o'clock and 5 seconds or so and 2:09, somewhere in that range, about 9 minutes.
That sounds accurate.
She didn't mention it the second time either, did she?
I don't believe so, no.
We asked her to write out a written statement, yes? Or she was willing to write one out?
She was willing and she did, yes.
Now you don't tell people what to write in their written statement, correct?
Correct.
You don't tell them to conceal or omit facts, do you?
I do not.
You don't say, look, just put part of this in there, but anything that may look bad for you, feel free to leave out. You would never do that.
No.
And if I were to say to you that there's a claim that you told Mrs. Scatarassi not to include any reference to the cameras being disabled, you would say that's false.
I would say that's false. Correct.
And if I were to say to you that Mrs. Scadarassi or someone, there's a claim that you told her to just exclude certain information from her written statement, you would also say that's false.
Correct.
Now, as Mrs. Scadarassi was leaving at about 2:37 in the morning, so we're now about an hour or so into your interaction with her. She's still at the police station. And as she's about leaving, there is a discussion about the interior kitchen camera, correct?
I don't recall.
Okay. At that point, prior to her leaving the police station, she never mentioned to you that she had disabled the front door ring camera, correct?
That's correct.
At 3:41, now at 3:41 in the morning, you call Mrs. Scadarassi on the phone, yes?
Mr. Scadarassi?
Mrs. Scadarassi.
Mrs. Scadarassi, I did contact her.
Now, this is 2 hours after your first interaction with her.
Yes.
After multiple interactions with her in the lobby of the police department, yes?
Yes.
And after having gone out to the scene and speaking with Mr. Scadarassi, am I correct?
Correct.
And you return, and Mr. Scadarassi had shared some information with you. He had shared some ring camera videos with you.
Correct.
You got information from him about the ring camera videos that Mrs. Scadarassi didn't tell you about.
That's correct.
If I were to tell you, if I were to ask you, if someone said, well, Mrs. Scadarassi told you about the disabling the exterior camera at the house, at the police department, that would just be untrue, correct?
Correct.
You called her on the phone, yes?
That's correct.
And you put her on speakerphone, right?
Yes.
And you had a purpose in calling her, right?
Yes.
And the purpose in calling her was to question her about information that you got from Mr. Scadarassi, specifically about the ring cameras that she didn't tell you about.
That's correct.
And you confronted her about, one, why didn't she tell you, right?
That's correct.
And you confronted her about why she disabled the exterior camera and why she disabled the interior camera.
That's correct.
And one of the things that you do is when you investigate a case is you're obviously looking for evidence of the allegation of the alleged crime. Yes?
That's correct.
When you were speaking with Mr. Scadarassi, this is a question that he asked you. He put the question, you had said, well, you had already talked to her and you'd already talked to Mr. Scadarassi. Yes?
I don't recall if he asked that question or not.
Well, let me see if this refreshes your recollection. If not, I can go to the video. He inquired of you, what did she say happened? What was her version? Remember that question?
I do not recall him asking that specific question. If he did ask it, I don't recall.
Do you remember actually explaining her version to Mr. Scadarassi as, quote, it's out there, unquote?
I don't recall.
When you use the phrase, it's out there, have you used that phrase before?
Objection, asked and answered.
I don't
Your Honor.
recall.
He said
Wait a
he
minute.
used it. Would you like me to repeat?
Yeah.
I said asked and answered. He had already said that he never used that phrase.
Sustained.
Okay. I don't think
You want to rephrase? Go ahead.
Sure, I'll be happy to. Have you ever, in the course of your, how old are you?
31.
In the course of your 31 years, have you ever heard that phrase in just common jargon, like it's out there?
Objection, Your Honor. None of this is relevant.
I disagree. He's investigating the case, and I'm going to lead up to the point. I'll make my offer of proof.
Go ahead.
he literally told Mr. Scadarassi that which I'll play on the video in a moment, that Mrs. Scadarrassi's version was, quote, "It's out there," which I believe is a reference to, it's so strange, it's so out there, like bizarre. And then there was a further discussion later on where.
Listen, I'm going to let you ask that question, but you're really asking, I mean, I've been sitting here and she's not objecting. You're really asking for a lot of hearsay both ways.
This one is hearsay? Okay.
Well, yeah, if he's saying, he's repeating what she said, it's out there.
Oh, he's saying, that's his statement.
It's out there.
It's out there. Like to characterize.
Ask this question, but I'm just telling you, you're going through a lot of hearsay.
Okay. The phrase "it's out there," you understand, you've used it or heard of it in just common jargon. You've understand it to be used as.
If you're currently using or planning to use any of these companies and you can see your car listed here, then you.
Bizarre. It's something that's strange.
I think that it could be interpreted as one way that you could use that word.
Which way did you lean it?
I don't recall saying it in the first place.
Okay.
You thought her account was strange.
Objection, speculation, Your Honor.
Well,
that's fair.
That's not speculation, but it's argumentative.
I would try. There came a point further where you were talking to Mr. Scadarassi and you were discussing what evidence there was that you had gathered in your investigation about, I'm talking about you now, of either his account or her account, correct?
Correct.
And is it true that you said that there was no evidence? I'm just asking about your statement to Mr. Scadarassi, you. So you said there's no evidence of Mrs. Scadarrassi's claims. Isn't that what you told Mr. Scadarassi at his house?
I don't recall.
Did you ever check, one way to attempt to verify at least part of her account was to check her computer for spyware? Right?
Are you asking me?
Yeah, I'm asking you. I mean, she complained of spyware being on her computer.
Objection, Your Honor. It calls for hearsay.
I would try. Did you investigate whether Mrs. Scadarrassi's computer had any spyware on it?
I did not know.
How do you know that she wasn't searching for financial data in the course of her separation from her husband?
Objection, Your Honor. That calls for speculation.
I'm asking, how does he know?
It calls for speculation. It's not relevant.
Okay. Well, let's go to this. So another way, you understood that there was a claim that Mrs. Scadarrassi had taken Mr. Scadarrassi's money from his home, correct?
Correct.
And Mr. Scadarrassi's firearm, correct?
Correct.
You didn't search Mrs. Scadarrassi's clothing, pockets, or anything else to check if she had money on her, correct?
Correct.
You didn't search her pockets, didn't search a purse, you didn't search her vehicle, correct?
Correct.
I recognize that you could have sought different ways to have searched any of those things to look for evidence corroborating Mr. Scadarrassi's claim that she had taken the money.
I know, but you're still talking about hearsay.
What's the hearsay?
How is that?
I'm asking if he did anything to corroborate.
Mr. Scadarrassi, you're referring to statements that Mr. Scadarrassi's made, right?
I'm past that. I'm now referring to whether an investigation, did he actually conduct any investigation? Didn't search her pockets, didn't search her vehicle, didn't search Mrs. Scadarrassi's purse. Did you search any of those things?
Wait a minute.
Yeah.
You're really filling this thing with hearsay. I'm not saying anything. The prosecutor isn't objecting. When you're asking him about statements that he makes, unless there's an exception, it's hearsay. If you're asking what your client stated, unless it's admission against interest, and I know you're too good to ask those kinds of questions, it's hearsay unless you have an exception. I'm just asking you to move on. Okay?
Okay. I'm not dealing with hearsay here, Your Honor.
Well, you've been dealing with hearsay. If you haven't asked at least 20 questions that call for hearsay in the last 35, then I don't know what I'm doing.
Well, I beg to differ, but I'll
ask your next question.
Sure.
We'll take it one at a time.
Did you search Mrs. Scadarrassi's vehicle?
I did not.
Did you search Mrs. Scotarassi's phone?
I did not.
Did you search Mrs. Scotarassi's, did you do any investigation at all of the path between let me back up, the path between Mr. Scotarassi's home and the police station? Did you go look at that path?
The route she drove.
The route she drove?
I did not.
When you arrived at Mr. Scotarassi's home, you sought to interview him. Am I correct?
That's correct.
He cooperated with you?
He did.
He spoke with you and agreed to write a written statement. Am I correct?
He did. Yes.
You never searched Mr. Scotarassi's home for a gun?
I did not.
Never searched Mr. Scotarassi's home for the money that was reportedly missing?
I did not.
Never searched Mr. Scotarassi's vehicle for the gun or the money?
That's correct.
What my point is, who reported that the money was missing?
Sound familiar? Everyone's hyping AI coding. You try Cursor, but it just doesn't live up to the hype in your real code.
I hadn't asked that question.
Yeah, you did. You said you didn't check for the money that was reported stolen. Reportedly stolen. So where did that come from? It had to come from somebody. He wasn't there. There's no evidence he saw it on a camera. Somebody had to ask the question. Somebody had to make the statement. And it's hearsay, or it's a lack of foundation, or both. Okay? Can we move on?
Judge, let me make my record. Humbly and respectfully, I disagree. I think that there's no evidence in this case of the allegations that Mrs. Scatarassi made against Mr. Scatarassi. I believe that not only is there no evidence of it, but I believe that Mrs. Scatarassi's credibility is nil.
I understand where you're going.
And I believe that I'm entitled, in fact, I would say that I'm duty bound to follow up with what investigation the police did to investigate whether Mr. Scatarassi, whether the money was missing, whether there was a gun, any of the things, that Mrs. Scatarassi happened to claim. Remember, she denied taking his money. She denied taking the gun. She wasn't, and she testified to that, as I recall. She wasn't searched. Her vehicle wasn't searched.
I don't remember hearing her ever say that there was, the only time I ever heard anything about anybody saying that there was an accusation of money being stolen was that she reported that when she was testifying that that's what your client said. You stole my effing money is what she testified to, as I recall it, which would be deemed an admission, right? It's against his interest. It's not in support of his interest.
It's against his interest to claim that she stole his money?
I'm saying that there was a reason why you're not going to object to hearsay. That is not hearsay. If the prosecutor's introducing that statement, as she did on direct, that's not hearsay. We know. I mean,
I'll share with you my recollection. My recollection, again, this is my recollection. My recollection is that Mrs. Scatarassi she testified on direct examination and testified on cross-examination that she didn't take his gun and that she didn't take his money. And I believe that I not only is it important and relevant, but I think I'm duty bound to ask this detective, this officer, when you interviewed her, did you just took her word for it? Did you pat her down? Did you look? Did you examine her? There were conversations about the money and the gun.
Why don't you ask the next question? And we'll go from there. Go ahead. Ask your next question. I mean, I think you pretty much established he didn't do any of the follow-up that you think he should have done. He didn't go and check for the spyware. He didn't go and search for the gun. He didn't investigate whether or not money was stolen.
What's the reason? And I appreciate that, but For purposes of the case.
Because you're saying it goes to her credibility. I get all that. I'm just saying you've established all of that, don't you think? I mean, which aspect of that?
I hope so.
Okay.
I hope we've established it. So ring cameras are something that police officers are now forced to or are accustomed to dealing with on a regular basis. Yes?
That's correct.
Did you go to any of the neighboring homes around Mr. Scotarassi's home and check if they had any ring camera showing Mr. Scotarassi entering or leaving the home?
No. To clarify, his ring camera shows her approaching the home and entering.
He has neighbors.
Yes.
I'm talking about the neighbors.
No.
Shows her entering the home. Yes?
It shows her approaching the home.
Approaching the home.
And the secondary camera shows her inside the home.
Yes. I'm talking about.
We did not go to the neighbors.
Neighbors to see whether she was walking out with something in her hands, or whether she was walking out with a gun, or walking out with money, or walking out with anything, or walking out barehanded, right?
That's correct. We did not.
You've responded to domestic violence calls in the past, haven't you?
That's correct.
And you understand that where there's reasonable cause, as a police officer, reasonable cause to believe that a crime of domestic violence occurred, you can make an arrest of the alleged perpetrator, correct?
Correct.
Despite Mrs. Scotarassi making her claims to you at the police department, you did not go out and arrest Mr. Scotarassi on that date, am I correct?
That's correct.
Mrs. Scotarassi did not evidence any physical injury, am I correct?
That's correct.
Apart from her word, there was no evidence of her allegations, am I correct?
That's correct.
With Monday.com's intuitive work management platform, you have the power, not IT, not.
Have a second, Chairman.
Sure.
Thank you. Nothing else, Your Honor. Thank you.
Thank you. Redirect.
Yes, Your Honor, briefly.
I'm going to ask a couple questions.
Yes.
You said you looked at the tape of the interview between you and her in the lobby of the police station.
I did, that's correct.
Did that on Sunday night, 2 days ago? Is that to understand correctly?
Yes.
When I watched the video, when Mr. Rockheim played that video, I was a little unclear as to where she was pointing.
Correct.
You testified she didn't indicate to you in a written statement that he pointed the gun at her.
Correct. According to her, it stayed in the holster. He grabbed her with his left hand by the hair and raised the firearm near her head. She told us that it did not point at her. He didn't point it at her. He raised it up near her head while he was holding her hair.
Go ahead.
And I want to ask you about what you just said to the judge there. You said that she said he didn't point it at her.
That's correct.
Did she say that it was next to her head?
She said he pulled it up near her head and then did a motion of the firearm or
keep the voice up.
She said that it was not pointed at her, it was near her head.
So you stated that on cross, you stated that you documented in your report that the victim told you that the gun was never pointed at her.
Correct.
Is that correct? Okay. But did you document in your report what the victim stated happened with the gun?
Yes.
And during your interview with the victim, with the complaining witness, did she demonstrate to you what had happened with the gun?
She held up her arm like this.
And describe for me what you're doing right now.
I'm holding a fist where I was assuming that she was showing how he was motioning with the firearm in his hand.
Judge, just for the record, because we can't see.
Yeah, you have to describe it. So you've got a closed fist somewhere about 3-4 I don't want to put words in your mouth.
Right.
3-4 inches from the right side of your jaw, correct?
Correct. So she said his left arm. Would you like me to stand up?
Yeah,
Would that be easier?
stand up and demonstrate it the best that you can.
According to her, he had her hair with his left hand with a holstered firearm, was making statements and holding the firearm near her head.
Okay, and right now you're about 10 inches with your fist, which I suppose you're trying to describe as being the firearm.
Correct.
From the right side of your jaw. Is that true or false?
I'm just saying,
I want you to tell me.
he's in the middle of this.
I don't want him to say it. I don't want me to.
Towards her head, whether it was right here or farther out.
And right here, you said you had near the temple, and then you pulled your arm back out about another 15 inches. True. At one point, you said she had her hand up here, and you had it by her temple. Correct me if I'm wrong. If you want to redo it, I want it. It has to be described here. And then you pulled your fist away, and it was about 18 inches from 15 inches, I would say, from your head. Is that true?
That's to the best of what I recall her telling me the events of that.
So somewhere between 2 inches and 15 inches.
Yeah, roughly. I mean, she said it was right up next to her head.
Okay.
Next to, I guess, could be interpreted, 2 inches, 15 inches. I think in the realm of if he was holding her hair, I would imagine it was closer rather than farther.
But one thing I just want to add, if I could, to the visual demonstration. He has his fist, what looks like to be like around I presume is supposedly holding the gun. But the side of the gun would be to the side of her head, not the barrel ever pointing at her, which is why he wrote the barrel was never pointing at her.
That's correct. She said that he never pointed the gun at her.
Okay.
Thank you.
Okay. On cross, you stated that there was no other evidence besides her allegations. Did you direct her to make a written statement?
I requested if she would like to make one, or I asked her if she would like to make one, and she did.
And is a written statement considered evidence?
That's correct. It could be, yes.
Okay. And did you document in your report whether a threat was made or not?
I did, yes.
Sorry about that. And then I asked you about your report, and then during the interview, did you report that there was a threat made?
I did, yes.
Okay. And typically when you make an arrest, do you typically arrest every individual accused of domestic violence?
No.
Just one moment. Just a few more questions.
Take your time.
When she had demonstrated to you what had happened, did she demonstrate what had happened before she had walked into the police station?
No.
And
let me rephrase that question.
I didn't even understand it. What do you
Yeah.
mean, at what point? You're saying, did she demonstrate what happened before she got there? What do you mean, the whole day, the week, the
I
hour?
will rephrase the question.
Okay.
So I apologize for that. So you just demonstrated what she showed you with the gun. Did she report that any threat was made when that was happening?
I'm objecting to hearsay, Your Honor. It's not a prior.
Well,
inconsistent statement.
and I think he already answered that.
Your report, you testified that it was in the report.
That it was in the report. Okay, so you're asking now, did she indicate whether or not there was a threat made?
Yes.
And you're objecting on the basis of hearsay?
Yes.
Did you have any response?
He did just demonstrate to us what she said and
You
how.
can establish foundation for sure if you want to try to do an excited utterance. If you don't, you don't. If you can't establish the foundation, then I'm not going to let it in.
I can establish the foundation, Your Honor. When Ms. Gardarasi entered the police station, and she made a report, to your knowledge, was that report made? How much time had happened in between the report and the incident that was reported?
I believe roughly about a half hour, maybe a little less.
And how did she appear to you?
She appeared upset. I think she was attempting to hold back tears while she was explaining the situation that had just occurred.
And did she cry at all?
I believe she was wiping away tears during our entire encounter.
And when she had come in to make the report, did she indicate to you that a threat had happened?
I object to hearsay.
Did I believe I established foundation there.
I disagree.
I'm going to allow it. I mean, I observed her, and for the record too, the tape that was played certainly showed she was under the stress or excitement of the startling event or condition. So I'm going to ask you to answer that.
Okay, can you rephrase the question for me?
Did she indicate to you that a threat was made?
Did she
During the
indicate
incident.
whether or not a threat was made to her?
That's correct, she did.
No further questions, Your Honor.
Any recross?
No.
You can step down. Thank you. Call your next witness.
Your Honor, the prosecution rests at this time.
Okay. You move the bind over?
Yes, Your Honor, if I may.
Sure. Unless you want Mr. Rockine to argue first, and you can rebut it. It's up to you, whatever you want to do.
I can argue now. Your Honor, I want to kindly remind the court that the charges being considered here for bind over are assault with a dangerous weapon and felony firearm. For an assault with a dangerous weapon, the elements required are first that the defendant either attempted to commit a battery on the complainant or did an act that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendant intended either to injure the complainant or to make the complainant reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have that ability, or thought that he had the ability. And fourth, that it was committed with a dangerous weapon, which, as we know, is an object that is used in a way that is likely to cause serious physical injury or death. In this case, it is a gun. We heard a lot of testimony over the last few days that this exam took place, but the complainant clearly testified that her ex-husband, the defendant, threatened her by putting a gun to her head, showing us exactly how he did it, and that she was placed in fear for her life due to his actions. We saw the body cam footage that shows her fear and panic. We saw her speaking to the police officers almost immediately after the incident had occurred. And it shows exactly how she described it to the police officers, which was consistent with her statement on the stand. Everything that happened outside of this incident, all of the additional circumstances, would just be smoke and mirrors. The reasons why the complainant wanted the laptop password, how she attempted to do it, are all extrinsic factors that will be questions of fact for the trier of fact. The complainant was truthful and credible. She was consistent in her statement here and consistent in statements to the police. And it's important to remember that there's a probable cause standard here. And based on the elements of that assault by a dangerous weapon and the felony firearm that attaches, we believe that the elements have been satisfied and move for a bind over as charged.
We paint an alternative picture, or at least draw the court's attention to an alternative picture that comes from the facts of the case. Woman tells the police that she moved out of her home and she's been out of the home for a week to 10 days. She goes to the home like a burglar, sneaky, dishonest. She goes to the home at 1:40 or so in the morning, 1 something in the morning. Doesn't walk up the walkway, but actually walks up the side through like a burglar, like a stalker. Walks up the side of the home through the landscaping, through the grass, and actually attempts to sort of sulk, hiding herself by a camera, disables an exterior camera so that can't be seen when she actually enters the home, comes into the home, doesn't announce that she's coming, doesn't tell anybody that she's coming over, doesn't seek consent or permission. Quite candidly, there are circumstances where a person who entered into a home at night, even if they believe they had the permission to be there, could be deemed a burglar or someone that was engaged in a home invasion by the homeowner. There are people that if they were asleep and heard someone who they didn't expect to be in their home, would and could have taken action against someone who was engaged in what certainly sounds and looks like a home invasion first degree, entering into a home with intent. An intent to commit a crime inside, to commit a crime within, to commit a felony within. And once inside, they knew or know, or it turns out that a person was inside the home. That's a home invasion first degree. They can call her the victim all they want. Quite candidly, when this exam is over, regardless what happens, we're filing a police report against her. The best thing that happened in this case for her was when Your Honor appointed her a lawyer. The worst thing that happened to Mrs. Scardarossi in this case was when either the prosecutor gave her some sort of permissive, although unspoken, promise that we don't think she needs immunity, or her lawyer or someone advised her that she shouldn't seek to assert a privilege because she admitted to multiple crimes on this record. And one of the most dishonest acts I've seen by a complainant or a complaining witness or person in I don't know how long, but I digress. Inside the home.
Hey everyone, today I'm breaking down the top 5 collagen powders of the year and why the #1 pick.
And we'll get to her credibility in a moment. She takes a phone that she has until the second preliminary examination date identified as his phone. Told the police it was his phone. Told the officers it was his phone. Wrote it was his phone. The first day of testimony referred to it as his phone. Took that phone and then attempted to gain access to it without consent or without permission. Whatever person, whether it be on WikiLeaks, whether it be a friend, whether it be a kind detective who knows a friend, whomever gave her the idea that she should come in and testify the second or third time she was here, or the second time she was here, and say that that was marital property when she never characterized that before, did her a disservice because it was a lie. My biggest fear in this case is that the court won't find that she lied and will somehow find that her claims are credible, because they aren't. But she takes the phone out of the house. She goes down the street. She drives down the street. She then attempts to access the phone, which is another crime. Then she drives the phone back, comes into the house. There's an argument. There's absolutely no evidence whatsoever that what she says took place. There's no evidence that he pulled the gun. There's no evidence that he displayed the gun. There's no evidence that he brandished the gun. In fact, were the court to take a look at the video of the video that was played showing Mrs. Scardarossi in the kitchen when she crouched down and hid, although she testified she didn't crouch down and hid, when she testified that she didn't beckon the dog over, although the video shows her beckoning the dog over, that when you look at Mrs. Scardarossi in the home, Judge, take a look. Remember, she testified that the gun, when she entered into the home, was actually on the kitchen counter or on the table. Look, we played the video. The court recalls the video. There was some interesting exchange between the court and the prosecutor about 421 versus 422. Clearly, you weren't referring to the time of day. You were referring to the time on the video. I know you remember that. I remember that. because we saw Mrs. Scadarassi. You can see in the kitchen, there's no evidence of a gun on the counter. And the police didn't search Mrs. Scadarassi for it. The police and Mr. Scadarassi, as we could tell, because Mrs. Scadarassi said this, there was some question later on. The police questioned her about where the gun was. But never did they actually do any kind of search for evidence in this case. Mrs. Scott, there's an argument, there's a discussion. These are facts now. Put aside, Mrs. Scadarassi leaves. She's in the middle of a separation from Mr. Scadarassi. She has a divorce lawyer, which she admitted to us. She'd already consulted with her divorce lawyer before this happened. There's a business, there's a dispute over a business. And I addressed some of that with the court. And then she's busted breaking into the house by Mr. Scadarassi, busted, like he catches her. She then goes to the police department and it comes up with this story, for which there is not a single shred of evidence. No gun, no money, no wound, no injury. What do we have? We have Mrs. Scadarassi's testimony. Did she act like a person who was trustworthy when she went to the house that day? Take a look at the video. Does an honest person enter into the home by disabling the exterior camera? No. Does a dishonest person traipse through? Does an honest person traipse through their landscaping? No. You could see, and she wanted to quibble with me over how she went about trying to remove the camera. You can see her up against the side of the wall trying to remove the camera, and then it's gone. We would see what happened inside if something had happened if she hadn't disabled the cameras. What a perfect ruse. Take my word for it. There's no evidence, but take my word for it. Even though I disabled the cameras that could have provided evidence of me leading with the gun or not, as Mr. Scadarassi claimed, leading with the money or not, as Mr. Scadarassi claimed, or this allegation of a violent assault or an allegation of an assault for which there's no evidence. We would see whether that occurred or not, but we can't. So what do we have? We have Mrs. Scadarassi's word. Let's break down her word. She testified here on her oath. I specifically asked her that, on your oath, did you tell the police when you were at the Brownstown Police Department about disabling the exterior camera? Does the court recall the answer? I do. She swore that on her oath that she did it. She swore she had seen the body camera. I know it's there. I know that it's on the camera. I know that that's what I did. I know I told the police that, she said. Except we have the officer who has no stake in the outcome of the case, who literally says, no, she didn't. He had to call her 2 hours later after learning from Mr. Scadarassi about the exterior camera being disabled to actually call and question her as to both why didn't you tell me and why did you do it? That's dishonest.
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere.
Have you heard about Ryoko?
2, she didn't disclose to the police that she had, when she was in the lobby, disclose to the police the disabling of the interior camera. That came 2 videos later. She didn't disclose to the police. She didn't include any of those facts in her written statement, which we admitted for purposes of impeachment as a defense exhibit. I questioned her about that. She conceded in her written statement, and then what she did is she said, well, the police officer told me not to include those things, to just include certain things in my written statement, and I'm paraphrasing. I asked Officer Lee, did you tell her to admit anything? He says no, of course not. Another bit of testimony that wasn't true. She testified that he pointed the gun at her neck. I mean, I know the court recalls that testimony. She swore again on her oath that, one, she was very clear. I'm going to use right hand because that's my dominant hand, but she was very clear. Does the court remember how she did it?
Of course I do.
Right. She said that she had her finger, wasn't hard. It's like you do as a child. Remember when we're playing guns and cops and robbers? No offense to the cops. Cops and robbers, or you have a gun and you use your finger as the barrel. She was very able here in court to demonstrate. She said that took 2 fingers or 1 finger and held it to her neck. I'm not using the correct side. I understand. I'm just demonstrating. She was to my neck, pointed. And she went to the point of trying to tell us that the gun wasn't, that when I said directly pointed, I was just talking about pointed from afar, not pointed close. Also, we have the officer here testify. What did you put in your report? Never pointed the gun at her. Did you write that the pointed the barrel of the gun at your neck? No. Did she demonstrate that the barrel of the gun was pointed at her neck? No. Did she demonstrate with like fingers shaped like a gun that the gun was pointed at her neck? No. Did you write never pointed the gun at her neck? Yes. Had she said that the gun was pointed at her neck, not beside, this allegation of being beside her head, but had you been told that, would that be a fact you put in your report? Yes, because it's an important fact. Not her testimony in court last time and previously was untrue. That's untruthful testimony. What should the prosecutor have done with all due respect to her? She should have pulled the plug on this case at that point. To stand here and make a claim that the witness was credible, that her story was consistent, without breaking down the details of the case, does a disservice to any witness who's come in here and attempted to be credible and deserves the moniker of credible and consistent. She was anything but credible and anything but consistent. I can break down even more. She testified, said, "Oh, I thought it was marital property." She didn't testify that was her testimony last time. That was after the court had advised her that you were going to appoint her a lawyer, and that she had time to consult with her lawyer, and she had time to talk to the prosecutor, was her testimony, and that she had time to talk to some friend of hers who was a lawyer, who we don't know who that person is. I don't know if it's a divorce lawyer or the guy at the end of the bar that just happens to be a lawyer. I don't know. Who knows? We have no idea. Don't know who that person is. Could be something she read online. I don't know. You don't know. But she used the word his phone, all throughout her discussions with the police, as the officer conceded. But then after the court appoints her a lawyer and she talks to somebody and she knows that she's in potential criminal jeopardy, she actually says, "Oh, I thought it was marital property." So let me get this straight. The credible, reasonable explanation is that you broke into a house after disabling the cameras like a burglar, and you then took the phone that you thought was marital property off your husband's sleeping chest, your soon-to-be ex-husband's sleeping chest, and you left with it. You took it out of the house. I mean, it's preposterous. The story, I mean, quite honestly, I sat there and thought, man, she should plead the fifth. To be frank with you, I'm pleased that she didn't, because I've got a record. So we've got his phone and the change to, I thought it was marital property. We've got a claim where she, of course, didn't have consent. She concedes she didn't have, the first time we testified, of course she didn't testify that she didn't believe she had consent, and I'm paraphrasing again, or permission to access his phone. She didn't have permission to go into the computers after hours at his work, to attempt to access the computers at work, another dishonest act. I'm going to tell you, any one of us had a spouse or ex-spouse that was going to our office or to your computer or phone trying to do it at night. You would be like, what are you doing? That's a crime. I mean, it's criminal.
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device.
Says he tried to access his laptop too. Never referred to it as marital property anywhere, except after she's facing potential jeopardy, her answer changes. She told the police, she testified before you, sworn her oath, that she told the police about disabling the cameras. We hear today, that's not true. So when someone omits something or conceals something important, particularly something that puts them in a false or negative light, that weighs on their credibility. And I would posit to you, Judge, that Mrs. Scardarasi's credibility is zero. When I asked the officer the question today, when I asked him specifically, is there any evidence? Because that's what the police are supposed to do in theory, right? I mean, they're supposed to go out and attempt to collect evidence. The court questioned me about whether I was why I was getting into hearsay and why I, at the end of a sentence here or there, or that. But that's what the police are supposed to do, is to attempt to gather evidence. Either evidence, they had plenty of evidence that Mr. Scatarrasi had committed crimes, plenty. And I would posit to you, with all due respect to Your Honor, with all due respect to the Brownstown Police Department, with all due respect to the prosecutor's office, were the tables turned and a male had done this, and a female had made the claim, and a man who had moved out of the home and during the course of a marital separation, that the man went into the home and that this had happened, I suggest to you, Judge, that things would be much different. There is no way that man would not, under those circumstances, I cannot think of a circumstance in which the tables were turned that the police would be treating Mrs. Scatarrasi, or in that case, treating the male as the victim. Man takes his ex-wife's or soon-to-be ex-wife's phone, comes into the house late at night. She's only been there in the morning to help get the kids off to school. She hasn't been there on her own before that. She hasn't been there for a week. She's not laying down and sleeping there. She comes there at 1 a.m, disabling the cameras, and comes in. And then imagine a male doing that, sneaking into the home, disabling the exterior camera, sneaking in, crouching down in the kitchen, being caught in lies about whether you would beckon the dog over or not. And then he then takes his wife's phone off her sleeping chest, but there's no evidence that he had permission to do that. And he then leaves the house and goes into his car a block away and tries to find out who she's talking to or whatever, tries to access. That guy would be charged. Why? Because it's dishonest and it's criminal. For our purposes here, put aside the criminal for a second, it's dishonest. What Mrs. Scatarrasi did is dishonest. And what I would suggest to you, what she did, is that the police then attempted there's absolutely no corroboration of her account whatsoever, zero. And the only evidence of her account that's been offered today and yesterday and previously are inconsistencies and contradictions. And I would suggest, Judge, that there is no evidence upon which the court should confidently and comfortably bind over. I recognize the burden of proof is low. I recognize that it's only by a probable cause standard, but it's still a standard. And if you start at zero, not start halfway, but if you start at zero, so we've got, imagine if you would, like a meter that goes from 0 to 100, and you have to get to 51. Or whatever the courts these days interpret as, I know that's a preponderance of the evidence, but if they interpret the phrase probable cause, which should have some meaning. Imagine you start at 0. We've got her word, which ticks up a little bit, but then each word, each allegation that she's offered, you've got contradictions and inconsistencies. And on top of that, you've got criminal behavior. I would suggest you get nowhere close to probable cause. Let me add this. I know that the question was asked of the officer, well, do you always arrest people when there's an allegation of domestic violence? And the answer was no. But you, Judge, I asked that question for a reason. Where there is reasonable cause to believe that an act of domestic violence occurred, you can make an arrest. And the police typically, or I would say regularly do. And in this case, they didn't. Why? Because there's no evidence of it. And on top of that, they want you to bind over not just an allegation of assault with a dangerous weapon, but they want you to bind over on felony firearm. They don't even have a gun in evidence. They don't have a gun, they don't have the gun. Let me posit this to you, Judge. If in theory, if as the state says, and it accepts Mrs. Scatarrasi's account that in some way that Mr. Scatarrasi used a gun in this way. So the police are coming out to Mr. Scatarrasi's house. They come out there. He doesn't know when. How would they know when? They drive out to the house. They have every ability to conduct a search, whether it's by consent or whether it's by search warrant, of the entire property, his home, belongings, places, compartments, any place, car. And if they don't have his consent, they could certainly seek to wake you up, which I certainly hope that you wouldn't mind, but I'm sure you've been woken up plenty of times to sign search warrants. And they could wake you up and say, Judge, we got a case where there's an allegation of a man who is alleged to have committed the crime of assault with a dangerous weapon and domestic violence. And this gun we don't have it. And we don't have reason to believe that he left the house and put it somewhere, which means we have reason to believe it's in the house or the alleged victim has it. I bet you'd sign that search warrant. And, well, they didn't do that. They didn't seek a search warrant. I would tell you that this is a scary case for anybody that's going through a separation or a divorce.
Hey guys, I made this quick review video for my subscribers to let you know about a great survival resource that
It is incredibly scary that someone can take the stand, admit to a bunch of criminal activity, be as dishonest and I haven't just made the generalization that she's been dishonest, but pointed out specifics about her dishonesty and her lack of credibility on key points. If she would testify that the gun was pointed at her neck and sat here and tried to actually deny what was on the video that we played for, tried to deny that she claimed that the gun wasn't pointed directly, that she denied saying that the gun wasn't pointed directly at her. She tried to claim that she told the police officers, she demonstrated for me that the gun was pointed at her neck like I'm doing now in some way. You're telling me, and the police officer here testifies, the video shows that's not true, and the police officer testified that's not true, and yet there's a request by the state to have Mr. Scardarossi bound over based upon that person's word, and I would suggest that that is shameful. And I asked the court to dismiss the case. Now, I recognize, by the way, that if you dismiss the case doesn't end. Excuse me, I should make that an important point for the state to point out. Doesn't end, does it?
No.
All you could do is dismiss counts 1 and 2.
Correct.
And it would leave a domestic violence case before you, which I recognize is all we can do today, is to seek a dismissal of counts 1 and 2, and that's what I'm doing.
Thanks.
Your Honor, I'm not going to lecture you. I'll keep it short. But
You're not going to lecture me?
I didn't lecture you.
I really want to reel it back in. And I want to focus on the third element of assault with a dangerous weapon, which is that at the time the defendant had the ability to commit a battery or appeared to have the ability or thought that he had the ability. The defense has said a lot here, and specifically regarding the gun and whether or not it was near her head or pointed. Regardless, these are questions of fact. Whether a gun is near your head or pointed at your head, a person would be reasonable to believe that the person holding the gun has the ability to cause injury. The reasons why she was there that night are all extraneous factors here. They are all irrelevant, and they are all questions of fact for the trier of fact. They are not relevant here today for this probable cause standard. She indicated that she didn't want him to know she was there and that she had entered that way because she was in fear of him. All of the allegations about her acts and whatever crime that she had allegedly done, first she testified that they were married, that she had a key to the house, that she was allowed to go there freely. And she testified truthfully the entire time. He claims that she was dishonest. She was very honest, and she said everything she did that night and why she did it. Again, all of these factors are questions of fact for the trier of fact. Probable cause standard. She testified consistently to what happened that night, and she testified consistently to what she said to the police that night. She said that there was a gun near her head and that she was in fear of her life. Any allegations of her incredibility are questions of fact to be heard at a trial, and we move for a bind over arrest charge.
All right. I always feel like when I start these exams and then they continue 2 weeks later and continues a couple weeks later than that I'm, how do I say it, a little bit at a disadvantage. I mean, I'd like to think my memory is as sharp as it was 30 years ago, but I'm not so sure about that. But I am sure that defendant is charged. We have 3 counts: felonious assault, felony firearm, and domestic violence. And this arises out of an incident which occurred on April the 10th, 2024 in Browns Township. And the scene of the alleged crime occurred at, was it 25801 Chelsea Creek Drive in Brownstown. Ms. Scottarossi indicated that she and the defendant, Mr. Scottarossi, separated a week earlier, and that she had at that time been living with her mother since she moved out. She had a key to the home and would come there in the morning and get the kids ready for school. There was a lot of testimony concerning the comings and goings of the victim in and out of the defendant's business and the residence that they occupied together until she'd left the week prior. After attempting to access codes from a computer at the defendant's business, which was named, I believe, Silver Touch Landscaping in Romulus, and she did have a key to that business, she then went to the residence again at 25801 Chelsea Creek in Brownstown. And I believe that the testimony was, and I think it's kind of confirmed here, my recollection was that it was sometime initially between 12 and 1 a.m. when she arrived at the business and then went over to the residence on Chelsea Creek. Sometime around 1 a.m. or whenever it was, early morning of April the 10th, she acknowledged that she did disable the security system, that she was secretive, and she gained access to his phone. She wanted to delete some spyware from her computer and believed she could do that if she could access the code in the defendant's phone. She drove to the Kroger parking lot after she entered the home and acquired the defendant's phone. And I believe the testimony was she wasn't able to access the code. She returned to the residence and was ultimately encountered by the defendant. She testified that after the defendant observed her, he walked to the end of a table and picked up his gun. I don't see anything in the video to corroborate that or to indicate that that is untruthful. She testified that at some point the defendant was about 15 feet away and he walked through a gate and came up to her, grabbed her in the back of her hair, and placed the pistol under her chin. That was the testimony. She had it pointed, and I specifically asked her, I believe, was the left side of her neck where she was indicating that that was in court. She indicated that the gun was a 9mm Smith & Wesson, and that the defendant had his finger on the trigger pointing it under her chin. That was the testimony again in court. She further testified that the defendant said, "Give me my effing money." I'm not going to state the whole word. To which she replied, "I don't have your money." According to the victim, the defendant stated, "I'm going to kill you." And the defendant stated, then stated, "You know who else I'm going to kill?" ? And according to the victim, the defendant looked at the kids' bedrooms and said, "Everyone." She testified that her response was something to the effect that, "You better hope so." The victim testified that she was scared and in fear for her life. The defendant then put the gun back, according to her, in his waistband, pretended he was going to punch her in the face, stopping 1 inch from her face. Their dog, a Rottweiler, then, she said, got excited and jumped on the defendant. Ms. Scottarossi then left the residence and drove to the Brownstown Police Department. I don't think there's any question but that there are a lot of inconsistencies in the testimony here. I mean, you could point out several inconsistencies in her testimony.
Your workflow is important to us. Please wait indefinitely.
With Monday.com's intuitive work,
some of which may have been or may not have been deliberate. But two facts are clear. No matter how he had the gun pointed, if that's believed, that it would constitute a felonious assault. I don't care if he's pointing it at her neck with the barrel specifically pointing it at her, or if he's waving around the gun somewhere near her head and saying, I'm going to kill you. Again, all we need is an attempt to commit a battery or a reasonable apprehension by the victim to receive an immediate battery. And then you need an intent to make somebody reasonably fear an immediate battery. And third, also that the defendant had the ability, thought he had the ability, or appeared to have the ability to commit an assault, and fourth, that he used a dangerous weapon. So in my heart of hearts here, I'm very confident that I'm correct in binding over the defendant. There's certainly a fact question here. Credibility issues like this are going to be for the jury. A lot of what the defense points out may very well be persuasive to a jury, and whether the people can prove their case beyond a reasonable doubt is another issue. I will say, for the record, as long as we're talking about credibility, while I found some of her statements inconsistent, she is either one tremendous actress, or she appeared to be very credible to me, at least by her demeanor on the video when she was speaking to the police officer. So for those reasons, the court finds probable cause exists to believe that the crime of felonious assault was committed, as well as felony firearm. I'm going to bind the defendant over to the circuit court. The AOI date will be 2 weeks, 2 weeks from today, since the defendant is not in custody. And you do not object to the continuation of the bond, correct, counsel?
No objection, Your Honor.
So I'm going to go ahead and continue the bond. If everybody will just give me 1 minute, please, before 3:18. And the AOI date will be on April the 8th, Criminal Justice Center, on the charges contained in the complaint. Obviously, the domestic violence will accompany that. Is there anything else you need to bring up, Ms. Alloway?
Nothing further, Your
Mr.
Honor.
Rockheim?
No, Your Honor, thank you.
Nice to have you here, Mr. Rockheim.
Thank you.
Good luck to you, sir. Thank you. You can go right down the hall.
There I am. So what do you guys think about this content? I'm getting mixed feelings about all this. I looked at that poll. 75% said they liked the content and 25% said they didn't like the content. I like doing it because it's not stressful on me. It's just doing the research to get the content and putting it in the right playlists. But I don't mind doing this, and you're getting an education about the legal system. So I don't know. But that's it for today. Tomorrow is Judge Lanice Bryant, and I think that's going to be pretty interesting. It's like I said, sometimes I would deviate from a regular court dockets if I get different judges. And that's all part of the learning curve. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. And don't forget to hit the like button, and don't forget to hit that all notifications. I've been getting notifications when I go on live, so notifications are working. So make sure that you're subscribed and you hit the all notifications. That's it for today. I will see you guys tomorrow at 3:00 p.m. for Judge Lanice Bryant. So you all have a wonderful evening. Ciao, ciao, ta-ta. And if, for God's sakes, try to be a little bit good. But if you can't, it's understandable. All right, everybody, have a good one. Idiots. Yeah, I think you missed a pretty good part of the beginning of it. You're probably going to have to go back and replay it. But I'm done. That's it for today, ladies and gentlemen. I will see you guys tomorrow. Ciao, ciao, ta-ta. Good evening. And I'll see you tomorrow.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, now I'm standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.